Hey, I'm Nancy Cavey, National ERISA and IDI Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice. The Florida Bar Association says I've got to say that, so I've done that. But nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. If you are on disability benefits, in other words, you're on claim or you're in the process of applying for benefits, I think there's a lot that you need to know. But one of the most important things you need to know is one of the first defenses that a disability carrier will raise to your disability claim is what's called a misrepresentation defense. And I'm going to talk to you today about that misrepresentation defense, how to avoid making them, and how to avoid getting a letter from the disability carrier that says, too bad, so sad, we're not paying your benefits because of a misrepresentation on your application or enrollment forms. So we're going to talk about three things today. One, what does rescinding a disability insurance policy mean? Two, making false statements after you've applied for disability insurance benefits can doom your claim. And thirdly, don't mess with a disability carrier and fail to tell them about your work activity. The tale of how one attorney destroyed his case. Let's take a break for a moment before we get started in this week's episode. Welcome back to Winning Isn't Easy. Making false statements after you've applied for your insurance benefits can doom your claim. Do you know that many disability insurance policies have a concealment or fraud provision in the disability policy or plan? That can result in a forfeiture provision that allows the carrier to void or rescind the coverage if you make false statements relating to insurance. So let's talk about a common version of this provision. It may say something like this: concealment or fraud. With respect to the person insured under this policy, we provide no coverage for loss if, whether before or after the loss, when the person insured under this policy has, and here's the material part of this, intentionally concealed or misrepresented any material fact or circumstance, has engaged in fraudulent conduct, or has made materially false statements relating to this insurance. Now, that third one is where the disability carriers really ride hard. Now, this can apply not only to questions on your application for insurance, but when you apply and you're completing your application, you're going to complete a lot of forms. One of those is an activity of daily living form. And if you have not completed that accurately, that can come back and bite you. Now, you also may be speaking with the disability insurance adjuster, which quite frankly, I wouldn't be doing. I would only be communicating in writing. Or you may be asked to speak with an investigator from the disability insurance company. Any one of these three events is an opportunity for the disability carrier to say, look, you've intentionally concealed a material fact about your circumstances. Or more likely, you made a material false statement relating to this insurance. And that comes to play, particularly when they've got surveillance on you. So let me give you an example. Let's say you stop work and you apply for your short and long-term disability benefits for a back condition. You're asked, did you ever file a prior workers' compensation claim or ever file a personal injury lawsuit or ever file a prior short or long-term disability claim? Now, you're going to see that on an application. You might say no because you forgot you injured your back 5 years earlier in a workers' comp claim and you got some injections, or you were rear-ended, you got some medical care, and then ultimately you settled the personal injury claim, but didn't get any treatment. Or maybe a few years ago you filed for short-term disability benefits. Guess what? The disability carrier guaranteed is going to do a background check on you. They're going to pull what's called a medical canvas, a drug canvas. They're going to search the personal injury or workers' compensation records in the civil arena, and they're going to discover the truth. Now, you may have denied any one of these prior occurrences because you forgot about them, But the question ultimately is going to be, is the "I forgot" excuse enough to overcome a claims denial? So that's going to be potentially an issue for the court. And the question is going to be, is the misstatement that you made after a claim is filed an innocent mistake, or is it an incorrect statement or an intentionally incorrect statement? Now, I have to talk to you a little bit here like a lawyer. A false statement in the legal context includes an element of intent to mislead. And the court's going to look at the policy or plan to see if there's a definition of false statement. If there is, the court's going to apply that definition to the facts of your case. Now, if not, the court's going to get out the dictionary, like the American Heritage Dictionary, and they're going to look at what the ordinary dictionary meaning of the term is. Now, that sounds easy, but quite frankly, it's not. Get out the dictionary and look at the definition of a false statement. Now, it has two meanings. One is contrary to the facts or truth, or deliberately untrue. So which one is it? In the context of a legal proceeding, the term false has a connotation of intentionally deceptive statements, and it's in part requires sort of knowledge and an intent to deceive. So you've got to know, and you've got to be intentionally trying to deceive the disability insurance carrier. Now, while forgetting doesn't have an element of fraud, policy language isn't meaningless, and each word in that policy is going to be given meaning. Now, here in Florida, it's a well-settled law that a misstatement in or an admission from an application for insurance need not be intentional for recovery to be denied. And that's an old case called Kaiser versus Old Line Life Insurance Company. It's a 1998 case, but I promise you, at least here in the state of Florida, that case is cited all the time by the insurance company and accepted by the courts as a reason to uphold a denial of a case based on a policy rescission. Now, I also want you to understand that the courts have also ruled that incorrect post-claim statements have to be false as the term is defined in the policy or plan, and if not defined, based on the ordinary dictionary meaning. So the court's going to go through this same analysis if the disability carrier is denying your claim on the basis that you've made a false statement in your activity of daily living forms or other in conversations that you have with the adjuster or a field investigator. So be careful. Quite frankly, if you're asked to have a statement from the investigator, from the disability carrier, you should get an attorney. The bells should be going off because there is a reason why they want to take your statement or have a field visit. It is not to see how you're doing and how life is after you've filed your disability claim and offer their services and blessings. That's not what it's about. Got it? Okay, let's take a break.